everyone. This is Tom Zucchero from Houston Hennigan and ICAN. With me is the president and founder of ICAN, Nick Morgan. Nick, how are you doing today?
Doing well, Tom. Thanks.
We have an exciting and a little bit different program from our usual program. We have two artists joining us as guests who have filed a lawsuit against the SEC. Brian Frye, who's also a professor at the University of Kentucky School of Law. Hi, Brian. How are you?
Doing great. Nice to meet you.
And Jonathan Mann, who is a performing artist, extremely talented, and one of the two plaintiffs. Hi, Jonathan.
Hey there. Thanks for having us.
Oh, our pleasure. I think this will be another fascinating program. We always love people who sue the SEC. So, and the architect of the lawsuit is joining us as well, Jason Gottleib from Morrison and Conan, New York City. Hey, Jason.
Hi, everyone. I'm pleased to be here, and of course to represent my clients, Jonathan and Brian, as we're litigating this case.
Yeah, fantastic. Why don't we jump right into it and hear a little bit about the case? Nick, do you want to just give us some background in why two artists are plaintiffs suing the SEC?
So we'll let them speak to their complaint specifically, but Tom, as you know, a frequent topic that has come up on SEC Roundup is the limits of the SEC's jurisdiction, not just with regard to digital assets, but in general. And of course, the so-called Howey test from the 1940s has been in active play in litigation, normally where the SEC is the plaintiff suing someone alleging that they were involved in some way or another with a security. If there is no security, there is no jurisdiction by the SEC, so that's a very threshold issue. And the fascinating topic here, a couple of fascinating things. One is we're talking to plaintiffs against the SEC, which is a reversal of the usual scenario we face. But also we're talking about a very interesting instrument, a non-fungible token, or NFT. And I think as the gentleman will tell us, that has been the subject of some settled SEC matters that have really caused there to be more. The settled matters around NFTs have raised more questions than they have answered. And I think they'll speak to that issue in this lawsuit. But the way I first heard about this was by seeing Jonathan, who is also known as Song-a-day-Mann, who has created a song every day for the last 16 years, I think. I saw the music video related to this case, and I got to say, it's a great song. Set aside whatever you want to say about the case, it's a cool song. So anyway, that's sort of the general context for this case and why we're lucky enough to have these guys on SEC Roundup.
And the song is, I think, titled "I'm Suing the SEC," which we may make our theme song for this podcast.
We'll have to get the rights. We have to buy the NFT.
There you go.
Why don't we start with Brian and then Jonathan? Tell us a little bit about your concerns and why you took the step to file a lawsuit against the SEC.
Yeah, so it really all began. I mean, so yeah, for context, I write a song a day. I've been doing that since 2009. In January, it'll be 17 years of a song a day. And throughout that time, I've always looked for different ways to make a living doing this project. And it's gone through various iterations and various kind of things over the years. In 2017, I discovered the sort of idea of what sort of became NFTs. They didn't have a name. They weren't called that in 2017 yet. But there was a sort of small but passionate group of people in New York City who were messing around with this idea of putting things on the blockchain other than money. And that got me very interested as a way to possibly turn Song a Day into a profitable endeavor. And so once 2021 came around, and that's when the wider world sort of took notice of what NFTs are, I started the process of tokenizing, all my back catalog. And since the January 1st of 2022, I've been selling one song a day as an NFT every single day. We're coming up on 3 years of doing that. So, prior to coming into crypto in 2017, I literally, as you might imagine, didn't know what a security was. I had that word, I had heard it, or I'd heard of the SEC, but I didn't know what they did, and I didn't know what a security was. Part of the initiation into crypto is learning about these things because one has to. So fast forward to 2021, there was a project that came around right in the middle of the big hype cycle of that time, called Stoner Cats, which made $8 million, in a matter of hours, selling these little JPEGs of cats to people that want to buy them, with the promise of creating a 8-episode animated show on the internet. And so that happened, and they made their show, and the crypto crash came, and it affected NFTs just like everything else. And those NFTs that the Stoner Cats people had sold were essentially worthless, like most NFTs had become. But 2023 rolled around, and I woke up one day and I find that Stoner Cats has been sued, or has had an action against them by the SEC, accusing them of selling unregistered securities, saying that these little cat JPEGs that they sold were unregistered securities. And that really piqued my interest, because I knew there had been one other case that had happened, I think a week even before, called Impact Theory, which I didn't really look closely into, but I knew the Stoner Cats people, and I knew that at least I thought that they weren't selling, I thought that they weren't doing anything wrong. And so I was very interested to read the action against them. And I can remember reading through the whole thing, and reading it and waiting to get to the part where they described what made their project a security, and B, different from every other project that has ever existed in the NFT space. And spoiler alert, I never got to the point in the complaint where that's true, because it's just not there. So I wound up being extremely confused and frustrated and upset by this decision. And so that day I wrote a song called "This Song is a Security," which poking fun at the SEC, essentially saying, like, you're accusing Stoner Cats of doing this, well, I'm doing the exact same thing, so what's going on here? Somewhat ironically, maybe that song was my second highest selling song of all time, sold to a great lawyer in New York for around 6 ETH, which is like 30 grand at the time. And that was sort of what set me on the path that I'm on now, along with Brian, with the help of Jason, suing the SEC. And maybe Brian can take over from there about where he fits into all of this.
Well, let me just interrupt for a moment, saying "This Song is a Security" is available on YouTube and has 1,300 views. So when we finish the program, it'll have 1,301 views.
There you go.
Okay, Brian, let's go.
Amazing.
Tell us
So
your side.
yeah, so this lawsuit is actually kind of in some ways almost a 15-year journey for me, that began back in around 2007, 2008, when I was a junior associate at Sullivan and Cromwell in New York City, doing primarily securities litigation, and among other things, doing research into the kind of ontology or nature of what is a security for some of the cases I was working on. And like many other securities lawyers, before going to law school, I went to art school. And so I had a background as an artist as well as a lawyer. And the more I looked into the kind of the definition of the security provided by the Supreme Court and and the way the SEC had kind of conceptualized and operationalized that definition over time, the 80 plus years since Howie was decided, it struck me that the SEC's conception of what constituted a security reminded me an awful lot of art, specifically of conceptual art. Right, so conceptual art consists of an idea, not an object, right? And the way that the art market transacts in conceptual art is by artists creating certificates, which they then sell to collectors in editions of multiple certificates, each of which represents ownership of an edition of the artwork. And I was like, well, how is that not exactly identical to selling shares in a company? And it really bothered me. I thought about it for a long time. I went into being a law professor. I was thinking about, how do I write about this in a way that's going to resonate with people? I just couldn't really figure it out because it sounded so technical. And lawyers were like, "What are you talking about? Who would buy something like that? That doesn't make sense." And I was like, "Well, a lot of people actually buy stuff like that. That's something in the art market." Artists were like, "What are you talking about?" Like Jonathan, like security. What do you mean? Like, how could that possibly be? How could the SEC be relevant to what I'm doing? So what I realized what I needed to do for it to make sense to people was to kind of activate it, as it were, to turn it into an art project itself. So what I did was I wrote a law review article that I styled as the prospectus for the sale of a work of conceptual art titled SEC No Action Letter Request. And the work consisted of me sending a no action letter request to the SEC proposing to sell this work of conceptual art that consisted of sending the letter, right? And explaining to the SEC why the parameters of the project that I was proposing to sell satisfied literally all the criteria of the Howey test. And therefore, I believed that what I was doing was proposing to sell an unregistered security. And so they should tell me that I wasn't allowed to do it without registering because I would be violating the securities laws. So a friend of mine described it as the first ever SEC action letter request, like, come regulate me, please. Unsurprisingly, the SEC did not respond to my no action letter request, although I did eventually get a FOIA request satisfied from them that was entirely blacked out, except one line in one email where the lawyer, I believe the lawyer there, referred to my theory as fanciful, which I found quite amusing. In any case, I kind of let it, it picked up some attention. Matt Levine talked about it in Money Stuff a couple times. And essentially the consensus a lot of people had was, well, ha ha ha, very funny, but you're not really selling anything. This is more of a joke. So it's like, well, since when was you're not really selling this? People wouldn't really buy it. A defense to selling unregistered securities, right? That's nuts. That doesn't make any sense, but whatever, right? So I let it sit for a while, and then and this was 2019, right? 2021, the NFT market hits, and I was like, oh my god, right? It's like I fell asleep, dreamed of like an imaginary market and nothing. I woke up and there it was, right? So I was like, okay, now's my moment. And I just did it again, right? I sent the SEC another no action letter request. I said, I talked to you about this before. I did this project. You didn't respond to me. Now I'm going to do the same project, except it's going to be 50 NFTs instead of 50 certificates. I still think what I'm doing is selling unregistered securities, according to you. But because you didn't respond to my last no action letter request, I'm gonna assume that you don't think so. And I'm going to just rely on your decision not to respond, to assume that what I'm doing is okay. And went ahead and sold the NFTs. It was quite a successful collection. They didn't respond to the second no action letter request either. And I went on to kind of make similar observations over time. And so when Jonathan and Jason got together to pursue this action, they were thinking about, who else would be a good plaintiff to include in this particular action. And lo and behold, my name came up pretty quickly because I've been engaged in the space for such a long time, making similar kinds of observations, and was in a position to create a new project for the purpose of, which is the subject of the lawsuit, titled Cryptographic Tokens of Material Financial Benefit, which is notably similar to the project on offer by the people from Stoner Cats.
I love it.
So that's great. Jason, maybe you can tell us what you hope to accomplish with the lawsuit and what you think you will be able to accomplish. Luckily, you filed in Louisiana, which is in the Fifth Circuit, which may be a helpful venue for this case.
Thanks, Tom. Well, it's not luck. Brian lives there. Jonathan does
Yeah.
sales there, so we're there for a very good reason. It does happen to be in the Fifth Circuit. We'll see what any particular circuit thinks about it. I mean, one of the things we've seen in the law is very few appellate courts have reached any of these issues yet, right? All the decisions that folks cite in the securities realm are from the Southern District of New York, in the case of Kik, Telegram, Ripple, or Terraform from DDC, where the SEC is suing Binance. We've got some case law in the Northern District of California, but very little, if any of this, is rippled up, pardon the pun, to the appellate courts. So we'll have to wait to see what any appellate courts say on the subject, because right now all we have are a bunch of trial court rulings. So in terms of what we hope to accomplish with this, well, I guess there's sort of the broader hope, but then there's the narrower hope. Now, obviously, the broader hope is that we can establish a rule that where the subject that is being considered by the SEC or anyone else as potentially being an investment contract under the Howey test and therefore a security, when the object of that investment contract, if there even is one, is art, then it's very important to separate out art from investment contract. And to the extent that there's any kind of a call to be made, to remember that art is a protected First Amendment right, that art is fundamentally not and never has been considered a security, that the drafters of the 1933 Act, the Supreme Court justices who decided Howey, never had any idea in their mind that what they were drafting would be considered to cover art, and that art is something different. It's something special, and it's something that we really need to, frankly, support in America and not clamp down on it by making artists think that they have to go hire expensive securities lawyers before they can write a song and release it to the public, or sell their art. So we've got broader goals in this, but of course, most judges don't deal in broader goals. It's very rare you get a district court judge who's writing policy for the United States. This is one case; it's one controversy. What we're asking for is a declaratory judgment that the art projects as described in the complaint by Jonathan and by Brian are not investment contracts. And it's that simple and straightforward. Now, obviously, we would hope that we get that ruling and that ruling has some precedential value that can apply to others and that other courts would follow that. But ultimately, that's really what we're focused on is that issue in this case.
Well, I think it's really important, and it's unfortunate that you felt you had to go to court to get an answer to this question of what are the limits of the SEC's jurisdiction over instruments. But I think we applaud the fact that you're doing it, and we're going to keep track of the case, and maybe we can follow up. Hopefully, you make it past the pleading stage, and maybe we can offer some support. But we really appreciate you being on the program, and as we say, we're enthusiastic to see where your case goes. So thank you all for being on.